Good afternoon and welcome back. Now that the field marshal is done with you, I'm going to give you just some quick general tips on litigating in our corrupt court system without the deleterious and expensive effects of hiring the court's officer, the lawyer, and then we're going to Dwayne's world. Law is science. It is not art. And each word means some specific thing. Essentially what happens when you file a complaint or when one is filed against you, a question is asked. And if you ask the wrong question, you get the right answer to the wrong question and you lose. Our problem in the United States is we are victims of verbicide. We are being killed with words. Your founding documents in the Republic mention unalienable or unalienable rights. The politicians today talk about inalienable rights. How many people in here don't know the difference? Little, maybe around half, little less than half. Unalienable rights are rights which are God-given and cannot be taken away. Inalienable rights are state-granted and may be modified or taken away at the whim of the state. I have personally held in my hand a copy of the Declaration of Independence where they changed unalienable to inalienable. So you have to study to show yourself approved, and remember, each word means something. Remember also, you're filing a lawsuit, not a fact suit. And the facts are only relevant as you can bolt them to the law. I won a fact motion for a guy in California State Prison who was in the middle of an ugly divorce while he was in state prison. And he asked me to help him do this particular motion, the exact title of which escapes me. And I ran it by Michael, and Michael said, it's a fact motion. And the judge will either say yay or nay. On a law motion, the box in which the judge turns in is very confined. Now, whether they'll turn inside the box or not is another question. But on a law question, the confines are narrow. On a fact question, it's quite spacious. I cranked this thing up off the top of my head and sent the guy 5 or 6 copies because he was in jail, and I figured he didn't have an opportunity to get to a Xerox machine, and he wrote me about 6 weeks later. And he thanked me profusely, presented it to the judge, and the judge looked at the opposing attorney representing the about-to-be ex-wife and said, well, and the lawyer was looking at his shoes. You know you've got them when they're looking at their shoes. So that was a nice thank you letter to get. What we teach is that you ignore the facts and you concentrate on the law and you frame a constitutional argument to form a winner. You heard Michael go over probably 5 or 6 problems which ultimately would be best addressed by filing a petition for declaratory relief, asking the federal court to either declare a Texas state section of the Constitution or a Texas statute unconstitutional or unconstitutionally applied in the instant case, or ask the court to declare what the law is. Can the legislature amend the Constitution, or do they have to put it to a vote of the people? Those are all law questions. They are not fact questions. The fastest way for you to get your head handed to you on a platter is to come into one of these courts bleeding the Uniform Commercial Code, or status, or jurisdiction, or a lot of what we at Erwin Rommel disparage as patriot mythology. Now I want you to understand something. I personally agree with all that patriot mythology. And Dwayne also will agree with a great deal of it. What we've learned from Michael is it doesn't work. And since it doesn't work, don't do that. Do what works. And what works is raising constitutional questions. You present the court with Sophie's choice. You want the green death pill, or do you want the blue death pill? And when you put the judge in a cross like that, a lot of times they bring the opposing counsel, particularly if it's government, into chambers and they say, you know what? I don't want to litigate this, and I don't want it on my record, and I don't want to get overturned on appeal, and I'm getting real sick of you, counselor. Take this moron into a conference room and fix this, and fix it today. And if it happens to you that way, it won't be the first time it's happened to people that we know. If you insist on the Uniform Commercial Code in terms of your position, from this moment forward, never quote the Uniform Commercial Code again, ever, under any circumstance, unless it's not the Texas Commercial Code. You approach a Texas state judge with the Uniform Commercial Code, and you might as well talk to him in Swahili. But if you approach him with the Texas Commercial Code, and I imagine, what section in Texas is the UCC? 1.207. Okay, what they do in Illinois, it's 871 Illinois revised statutes. In Missouri, it's, 651, 671. What you must do is when you find the UCC site you're going to plead, you go into the law library, you access the Texas Commercial Code, and be absolutely metaphysically certain that the site you are using is a dead match for the Texas Commercial Code. And don't quote the UCC, quote the Texas statutes. Robert Fox, of which there is none whicher, has just forwarded this to me. And this is what Vernon's annotated Texas statutes at the Commercial Code looks like. We got that on camera, guys? Do not quote the UCC, quote the Texas state statute. You are probably familiar by now with corpus juris secundum under attorney and client. If you hire a client, an attorney, a licensed attorney to represent your interests, you are a ward of the court. Wards of the court in Black's Law Dictionary are persons of unsound mind or infants. I haven't talked to anyone in this room who appears to me to be of unsound mind. Further, the attorney's first duty is to the court, not to the client. Wherever the two conflict, the duties he owes to the court as an officer of the court in the administration of justice must take precedence. And these sites are Corpus Juris Secundum, Section 2, page 769, Section 4, page 802. In your Oxford Unabridged Dictionary of the English Language, 11 volumes, 575,000 entries, if you wonder why we do what we do, look up the word lawyer and look up the word liar. And it will take most of you in this room about 4 minutes to determine that there is a scientific, etymological, verifiable reason why those two words are connected phonetically in our language. It is not by accident. Here in Dallas, you have a local rule of civil court. It's Rule 5.6. About 7 years ago, it was at page 589. And it says, essentially, that people appearing pro se are appearing represented by counsel, their own counsel, and therefore they'll be held to all the rules of lawyers. And you're going to have to fight like hell to get the judge to recognize that you are something, but you are not under the terms of representation. The last thing you want in these corrupt courts is representation. You want counsel. As you'll hear Dwayne, perhaps, or you will hear on the false witness defense tapes that we market, he was confronted by a judge who just didn't understand the law because he couldn't read it. And he said to the judge, well, let me get this straight. Can I counsel with my lawyer? Well, of course you can. And Dwayne said, I see. Well, then can I lawyer with my counsel? And the judge froze and blinked and got up and walked out of the room. And he came back 20 minutes later, and there was no further discussion about Mr. Rogers' capacity to be a belligerent claimant in person in the exercise of right. There was no further discussion of representation. You remember in the 1950s, some of you, the book Why Johnny Can't Read? In the 1970s, somebody wrote up a follow-up volume. They called it Why Johnny Still Can't Read. Johnny is now the guy in that black pagan Roman monkey suit sitting up on that altar calling himself judge. Johnny also happens to have a law degree from Baylor, and he's your prosecuting attorney. And your advantage is you have one case most of the time, and they've got a whole slew of them. And basically, our problem in the United States is the government attorneys and the judges wouldn't know the law if it walked up and bit them on the behind. And that's your advantage when you learn how to exploit it and expose to the record, not to the court, but to the record for appeal, that that's what's going on. And remember, you are going up on appeal. If you get justice at the local level, the system broke down and something went wrong. Something went terrifyingly, frightening wrong. Now, if you want to talk to Mr. Wrong about that, Robert Fox beat the United States government, including an affidavit by Secretary of State James Baker on the first round. And I got news for you. You have probably a state treasure in this room in Robert Fox. And you might discourse with him about your particular legal problem if you get the opportunity. Because anybody that can beat the United States government on a passport issue at the local court, in federal court on the first round, has obviously learned something about this legal system. Y'all want to take the lawyer test? Name the law school dropout. Patrick Henry, author of the speech, "Give Me Liberty or Give Me Death," tried 1,000 cases before he was 31 years old. John Jay and John Marshall, two of the first 4 Chief Justices of the United States Supreme Court. William Wirt, Secretary of the Treasury in the first 3, somewhere in the first 3 or 4 administrations of the United States government. I think Wirt was also a signer of the Constitution and the Declaration of Independence. Roger Taney, Justice, United States Supreme Court. Daniel Webster, codifier of the American Language Dictionary, Secretary of State, 1840 to 42. Salmon Chase, Justice, United States Supreme Court. Abraham Lincoln and Stephen Douglas, Senator Stephen Douglas, President Abraham Lincoln. I'll give you a little aside. You know what the Lincoln-Douglas debates were? Lincoln spoke extemporaneously for 90 minutes. Stephen Douglas rebutted for 3 hours. Lincoln rebutted for 90 minutes. I submit to you quite candidly that Ross Perot, George Bush, Bill Clinton, Bob Dole, and all the rest of these goombas, except perhaps with the exception of Pat Buchanan, probably couldn't elucidate on anything of any worth for over 9 minutes. That's how the Lincoln-Douglas debates went. Clarence Darrow. Robert Morley, the chairman of the American Bar Association 1953 to 1954, and Strom Thurmond, who I believe became a lawyer sometime around the time of Ezekiel and still sits in the United States Senate today. Patrick Henry, John Jay, Marshall, Wirt, Taney, Webster, Chase, Lincoln, Douglas, Darrow, Morley, or Thurmond. Name the law school dropout.
Darrow.
All of them, or Darrow. See, I'm preaching to the choir. Chicago attorney Clarence Darrow, the name most closely associated with the aggressive defense of the disenfranchised and the dispossessed, was the law school dropout. Clarence Darrow studied law in Chicago for 1 year and dropped out of school. He went to the library and he trained himself. He took the bar and passed. He went through the screening committee process and passed. He paid his $5 fee, and sometime during the last decade of the 19th century, he was admitted to the Illinois Bar Association. You see, you have been violently deceived. The other gentleman in our test never went to law school. Now, you can decide if you'd want Patrick Henry to aggressively pursue and defend your rights, or one of the lawyers from the Watergate era. Remember those 20 Goombas who surrounded Nixon? Nixon, all the lawyers will appear on my hand. Nixon, Mitchell, Haldeman, Ehrlichman, Colson, Magruder, Liddy. I think only John Dean was not a lawyer. And that's where we are. All public school trained. As Dwayne says, all public fool trained. That's essentially where we're at. If you want to know exactly where you're at as I get ready to go over to the book table for our crazed and crass commercial message, in 1995, in the state of Texas, it's the Uniform Commercial Code. In 1840, it was called the Negotiable Instruments Laws east of the Mississippi. Texas probably didn't have a lot to do with that in 1840. In 1600, it was called Corporate Capacity in a Regulated Enterprise in the British Empire and Commonwealth. 100 years before the Messiah came to earth, it was called the Roman Law Merchant. 2,000 years before that, it was called the Babylonian Commercial Code. Commercial Code went from Nimrod in Babylon to Rome. As you heard Michael teach you yesterday, when they codified the common law in England some 500, 600, 700 years ago, that corrupt moron who did it simply cabbaged the 12 tables of the Roman Empire, that is the Babylonian Commercial Code, and bolted it up as the common law of England. The seeds of our trouble are laid at that point. We are now going to swing to your right and my left, and we're going to go directly to the crazed commercial messages. You ready for this? Can you all hear me? We're going to do this real fast just so you know what it is that we've got. My first book, written in Hendersonville, North Carolina in 1985. This is Avoid Bank Holidays. This is the supplement to the book. There's also an audio cassette tape that goes with it. If you have a bank account that you signed a Title 12 signature card for, you have a real problem on your hands. And what this book tells you is the area of law that you fell into when you signed the signature card on your bank account. The law knows no duress by consent. And unless you can demonstrate that they were holding a gun to your head, then you signed the contract willingly and you fall under the law willingly. This is our sort of mini health department. There's two more at the other end of the table. This is my father's book, Unhealthy Food, Unhealthy People. The biggest enemy in your house, and ladies, listen very closely, the biggest enemy to your family in your kitchen is your refrigerator, notwithstanding what the Kelvinator people have been telling you for the last 40 years. This book is absolutely unconditionally guaranteed to spin your head around like a top. Basically, most everything that you've been taught about food in America since 1940 is wrong. And dear old Dad has been a biochemist for over 63 years. And there's a wealth of wisdom in this book, and we highly recommend it. If you've heard of the Rife generator, what you really want is a multiple wave oscillator. This is The Secret of Life. Michael Brown wrote the introduction to this edition. Georges Lakhovsky invented the multiple wave oscillator, couldn't get it to work. Nikola Tesla, legend has it, came by and fixed Lakhovsky's oscillator and made it work and rode off into the sunset like the Lone Ranger. My associates with the Erwin Rommel School have seen prostate trouble, pancreas trouble, arthritis, and full-blown AIDS turned right around with a multiple wave oscillator. They are expensive. Become an informed consumer and read the book so you can, at least in your own mind, deal with informed consent. This is The Strength of Samson and How to Attain It. This is one of Michael's early works on health. This, among other things, is the Book of Judges meets the 20th century. You will learn why people in Muslim lands, even though they smoke cigarettes, have very little cancer or heart trouble. Michael has trained champion bodybuilders. He trained a world champion arm wrestler I believe, in the 1960s. And he's trained a lot of guys to make great improvements. Michael's a bodybuilder himself and a health advocate. And this may be the best bang for the buck on the table, except, of course, for dear old Dad's book. In fact, Michael has said himself in concert that probably the best addition to his book, Strength of Samson, would be my father's book on healthy food, on healthy people. This is the flagship of the fleet. This is the Bible the Pilgrims held at Plymouth Rock in 1620. And this is the 1599 Geneva Bible. If you're listening or watching on tape, send for our flyer and audio tape. When the Pilgrims stepped off Plymouth Rock, they didn't call this the Bible. They called it the Book of the Law. Had a person thank me profusely for having this for sale once. And he said, "Did you know that Abraham Lincoln was trained in law, not out of the King James Bible? His family had the Geneva Bible, and that's where Lincoln learned his law." The Geneva Bible is $120. When you order it through our office at that price, we send you our identity packet, which is in our catalog. The identity packet is Washington's Vision and Prophecy for America. It has a number of very controversial printings, none of which your incorporated pastor wants you to hear. The centerpiece of those is the instructions King James gave the translators of the King James Bible. You must remember, when you're dealing with a King James Bible, you are dealing with a government-censored document. And let the buyer beware. This is John Knox, selected writings of John Knox. The reason we're particularly enamored of this at Erwin Rommel is it contains the first blast of the trumpet against the monstrous regiment of women, authored by John Knox in 1558. John Knox was the principal translator of the Geneva Bible. He is the founder of the Presbyterian Church. This is $40 postage paid in our catalog and is unconditionally guaranteed to spin your contemporary pastor's head around like Linda Blair in The Exorcist. For you students of the Bible as law, as opposed to religious hooliganism, this is the Bible Law Index. It's a pretty good overview of the statutes, commandments, judgments, and ordinances in your King James Bible. 71% of them apply to civil government only. Only 29 apply to you as an individual. And this is something probably that your preacher wishes you had just not been introduced to. This is the Bible as law, as opposed to religious hooliganism. Dr. Leonard Zeich, a Baptist preacher in Oregon, he's not perfect. Parts of him are excellent. This has examined the evidence, the negative effects of incorporating a church as a 501c3 IRS tax-exempt entity. This is your Christian marriage. And if you, A, are married, B, are contemplating marriage, or C, know someone of an age where marriage might be in the offing, we absolutely cannot recommend this highly enough. You will learn the difference between contract, covenant, marriage license, marriage agreement, and biblical coverture. And what you ladies want is biblical coverture. When you have that, you are immune from civil process. You cannot sue. You cannot be sued. And for those of you who are wondering, yes, it's true the ladies did not vote. The husband, the head of household, voted pursuant to Christian patriarchy. If the husband predeceased the wife, she voted, but she did not cast the vote. The nearest male relative in the county cast the vote. The elections back then were by open ballot. They were verbally recorded, and everyone knew what their neighbor was voting for or who they were voting for. There was none of this secret ballot nonsense. The most controversial topic we have in our quiver regards plural marriage, sometimes miscalled polygamy. These are Ogden Kraut's books, Polygamy in the Bible and Jesus Was Married. You may readily discount all of the premises upon which Jesus Was Married is based. The lessons on marriage in it are worth far, far more than your disagreement with the premise of the book. Polygamy in the Bible, basically you can trace the suppression of plural marriage in Christendom with the rise of usury banking, which we will get to in a moment. And it is for that reason that the sound you hear in the background is your incorporated preacher going for the elevator. For those of you who want to bone up on the constitutional end of what you've learned here today, we have an audio seminar, $15. It's 3 hours long. It's Michael Brown in Chicago in fall of 1994. Constitutional law, what it is, how it works, and how to make it work for you. And this comes highly recommended. If you have a preacher friend or you attend a church that is unincorporated, this would make a great gift. This is J.T. Headley's Chaplains and Clergy of the American Revolution. And Texas, you ain't heard preaching like this. These are the recorded sermons at the time of the American War of Independence. And if we had preaching like this book today, the statistical probabilities are you people would not be in this room learning law from Michael and Dwayne. Chaplains and Clergy is not yet in our printed catalog. We just got this, and it's 15 Federal Reserve notes. This is Professor Abel Upsher's commentaries on Chief Justice of the Supreme Court Joseph Story's commentaries on the Constitution of the United States. This is a serious tool for N-Pro-Pers. We had a Texan pick this up about 2.5 months ago, and he defeated a civil action against him with one maxim he pulled out of one of the chapters here. This book was written in 1868, and this is a facsimile reproduction of every page of that book. This is our Sue the IRS and Feel Better Fast. It's $20 in our catalog. If you don't have one here today yet, it's $10. Basically, you're purchasing a jurisdictional statement. Don't ever boilerplate legal process against IRS agents, ever. You research your facts in the law library and make sure the dots connect. Otherwise, they will simply take a chainsaw out and they will carve you up like an ice sculpture, and that's not what we want. If you have a serious banking problem and you would like to learn how to do a RICO against a commercial lender, a bank, we have the original complaint under RICO and the Clayton Antitrust Act. We have the original complaint, the opening appeal brief, and the reply brief in one binder. We have the Supreme Court brief in another. We have a so special if you want it today. Otherwise, the price is in our catalog. This is a loser. Michael and this gentleman sued the Federal Farm Credit Bank. They sued a federal entity. Eighth Circuit overturned its own case law. The Supreme Court refused certiorari. Welcome to Babylon. If you want to learn how to structure a RICO, this is what you would want to use as a form only. Remember, it's a loser. You've been moving my stuff again, haven't you? No. This is Erwin Rommel's School of Law. This is 19 years of Michael's life compressed into 360-some pages. And as we told you earlier, we gave this to a guy in federal prison, and about 4.5 months later, he was out. You want to sue a judge on a complaint for judicial misconduct? It's right here. You want to sue state actors in federal court on a complaint pursuant to the racketeer influence corrupt organizations? The complaint's right in the book. There are some serious tools in this book, not the least of which is Chapter 24, Saturation Carpet Bombing, which will teach you how to deal with your state legislator who won't, or federal, who will not get up off of his butt and impeach the state or federal judge that he ought to be impeaching. Michael Brown's video series, Deuteronomy, It's the Law. Part 1 is Caste System, Legal System. Part 2 is titled, Is God's Law Done Away? And Part 3 is God's Law on Polygamy. If you want to disassociate yourself from an incorporated preacher, set this video in his mailbox. That pretty much ought to do it. The one thing I wish I had was the complimentary set of videos of Dwayne, mostly Dwayne, 1 hour of me. We have 12.5 hours in our catalog called The False Witness Defense. Now, Mr. Rogers is going to come up here in just a few minutes, and you're going to see why we have 12.5 hours of this on video. 5.5 hours is from Orlando, Florida, April '95. 7 hours is from right in this room in Dallas, Texas, in June '95. The audio of each program is $15. Either video program is $30. The complete package, all of the audios and all of the videos, is $65. And if you've heard me recite a price anywhere, it is all postage paid if you're dealing with our catalog. Sex, Money, and Power, the Bible Shows You How. This is Michael's latest book that I published. The book is $20. The audio seminar that goes with it is another $10, $30. Farrar Fenton, in his translation of the Bible, translates the word repent as change your way of thinking. And if you would like to start changing your way of thinking, Sex, Money, and Power, the Bible Shows You How, is for you. It discusses operating a business on Christian principles, health, advocacy, pursuant to strict biblical principles, and a host of other interesting topics. Clearly, two of the most serious and dangerous books in our catalog. This is the Bread set. This is Carol Collins' masterwork, Romance of the Wheat and the Upper Crust. It's 2 books in one. You will learn how to implement Give Us This Day Our Daily Bread in your kitchen on any day you choose to implement it. The problem with modern day bread is you're dealing with a product where there is more food value in the cardboard box it was shipped in than in the store-bought bread that you have available to you now. When you grind grain, if you do not immediately turn it to dough and then soak the dough for 7 hours, you might as well eat glue. And Miss Collins will show you how not to do that. We've seen families literally change their lives around with this book. The companion book was written in 1906, The Bleaching of Flour. It's the North Dakota Agricultural Station's Bulletin number 72 from 1906. Everything your banker and your baker pray that you will never learn. And last but not least, this is Life Without Usury. Who in here would like to take the usury test? Close your eyes and picture yourself in England in 1385. How many weeks will you work to supply your family with 1 year of food, clothing, shelter, medication, and recreation? The answer is 14 weeks. There were 200 national holidays in England, 180 in Germany, over 170 in France. You know what the difference was between then and now? After the Catholic Church beat the bubonic plague by opening the book of Leviticus and reinstituting the sanitation laws, the monks who did that discovered the money laws, and they made it a felony crime to borrow or lend at interest. And the result of that act alone was called the Renaissance. The great cathedrals of Europe and in England were built with volunteer material and volunteer labor. Now, your contemporary historians tell you that these people were crawling around in the primordial slime, barely able to make a living. The footnoted texts quoted in that book will tell you the exact opposite. Voltaire said, history is the tricks that the living play on the dead. You know what? Voltaire was right. You'll also learn in that book why the Muslims are the most hated group on the TV news. And the reason is the Muslims have reinstituted Sharia banking pursuant to the Levitical and Deuteronomy money laws. It is a crime in the Muslim lands to lend money at interest. In 1990, the Sharia banks wrote more new commercial loan business than the usury banks. And the people who control the television and who control the billions of dollars going to Egypt each year know that if the Muslims wake up and throw that government into the Suez Canal, everything in the Mideast is going to change like that. The Ayatollah Khomeini landed in Tehran, and he wasn't in his palace for 2 hours, and he brought the usurers before him. And he looked them over as a group, and he said, if you are here lending money tomorrow at sunset, you will be in the gallows within 24 hours. Have a nice day. You can't borrow money at interest in Iran. Well, you can, but you do so at the risk of being a capital felon. All right. That is our crass, crazed, and upfront commercial message. And now we are going to Dwayne's world. My friend and my personal counsel, Dwayne Rogers, is from Minnesota. Mr. Rogers, in his neighborhood, started building the fastest growing toxic waste hauling company in the United States after a series of business experiences, some positive and some negative. On the advice of his attorney, he incorporated this business after 3 or 4 years of running unincorporated. He was bankrupt 90 days later. Being stripped of absolutely everything, he undertook to study how it was that this could possibly have happened to him in what he perceived to be America. And what they did was they created a monster that they are to this day still unable to control. The gentleman who is about to address you, the gentleman who is the backbone of our presentation titled The False Witness Defense, has prepared over 300 American citizens for testimony before state and federal grand juries. As I speak to you now, not one has been indicted. From Grove City, Minnesota, someone who definitely knows something, Arthur Dwayne Rogers.
You honor me by being here again, and this time I brought all my tools with. I usually think that being a litigator means more than just knowing what to do. It's knowing how to do it. Most people know there's something to be done, but they don't know how to do it. So today, in conjunction with the Erwin Rommel School, I think Michael's been advertising this thing, 28 USC, and everybody that's doing any litigation should have one. It's probably the textbook, if you will. But I found something that complements it very well, and it's, what do we need, another thing turned on? And it's called the trial book. This thing is, and I'll hold it up later too, this thing is out of the William Mitchell School of Law, written in 1983, and it contains a synopsis of various legal techniques. But it's laid out in such a manner, thank you, it's laid out in such a manner that almost anyone can follow it, and it starts you off at the beginning and takes you right on through a trial. So every aspect of it. I just need it back here.
You can't hear a thing.
All right.
Speak up. Don't be shy.
So it starts off with a rather unique, what would you say, inventory. It has a table of contents that starts off with trial preparation, which is exactly what you should do. And it, strange enough, advocates that you write your closing statement at the beginning of the trial. So I need this closer. So it'll tell you in no uncertain terms that how you set up the case is determined by your closing argument. So your closing argument is what you're going to be doing all the way through the case. It selects out such things as a log for judges. So if you have a working relationship with the judges, you'll keep an inventory on him. The prosecuting attorney. For instance, I've had one prosecuting attorney in a local county that has never successfully prosecuted a case against anybody I've worked with because he makes some fatal errors. Usually he engages in argument with us and we call him as a witness. And of course that you obviously can't be the witness and the prosecuting attorney. So there are several things depending on your point of reference. Now what Erwin Rommel is about is prosecuting, and primarily 42 United States Code. So there's a different procedure for defenses than there is for what we say offensive. Now in most cases, if you're following similar to this trial book, it'll walk you through, let me see, case planning. For instance, it'll walk you through legal research. Along with legal research, you're going to meet and greet various actors in the courtroom, and they'll tell you plainly that this is a stage, and that everything you do is staged for the jury or the judge in some cases. But if you're prosecuting, you definitely do not want to upset the, what we say, conditions not in your favor. If you're defending, there's a different set of rules. So what we've tried to do is develop a book similar to this. In fact, you could literally reprint this book, and then, for instance, at the end of every chapter, they tell you how to avoid mistrials. And if you're a defense, of course, it's how do you cause mistrials. So it goes hand in hand. You have to know where you're at and what you're going to do. So what I was going to do is, for this particular presentation, is give you an idea of what you can do if you've got the book. So well, I'll just choose this out of this particular one, legal objections. I think you've heard us say that there are 38 legal objections. If you were going to know how to make those objections and you're in the courtroom, you have to have assistance, which is the next subject after this. In other words, counsel. So in this book, it sets it up in an outline form. It tells you all the legal objections and where to find it in this book. So 28 U.S.C. is dovetailed into this thing. In the back of it, it also cross-referenced it so you can find it easier. But if you're presenting opening arguments, there's a limited amount of objections you can make. If you're doing closing arguments, there's an increased opportunity to abuse, what would you say, facts and law that weren't introduced. So you'll often hear most of the, what we say, misstatements are at the end of the trial. Now, there's a reason for it, but nonetheless, this tells you how to object to it and how you set it up. So you can actually set it up that these people will misstate the law, and now you have an objection. Or you can close your ears and not pay attention and let them have control of the courtroom. My observation has been if they're listening to you, you're obviously in control of the courtroom. In any event, how to avoid mistrials is what we were concentrated on. So it would say in here, in order to preserve an issue for appeal, it must be placed on the record. So this is the reason for objections. If somebody's leading the witness, it's procedural, it is not grounds for mistrial. If somebody is misstating the law and you object or fail to object and the jury takes it to heart, you lose, and there is no procedural due process violation. If you object, it's considered on the record. So it's one of the things that you need to do. Now, how many of you belong to a law school or some regular meeting format where you can get together? Well, so there's a few in here. What we did at my place was set this thing up as the workshop primer. So every time you came in, we had basically the 20 positions that a courtroom takes, including the 12 jury members and the alternates, and you would get to play a different role every time you claimed a class. So you get to see how making and meeting objections, which is one of the books we sell, is improvised in the courtroom. Now, it sounds strange, but if you just did this 3 or 4 times, you would be better equipped than most lawyers. Most lawyers never see the inside of a courtroom. They're paper shufflers. So they don't get to stand up and make objections, and they don't get to do anything other than by paper. So if you had 3 experiences in front of your peers, you'd have more experience than most trial lawyers. In any event, if you wanted to cause a mistrial as opposed to avoiding one, then you have to unread the circumstances. So it says in order to preserve a condition for appeal, you have to make it on the record. All you have to do is fail to make a record of it. It's a failure of most individuals. They're afraid to be held in contempt or whatever. Okay, so it says you can't breach courtroom decorum. Now that's true to a limited extent. Most individuals who are not familiar with the courtroom, what we say, are intimidated and do whatever they're told. If we're defending again as opposed to prosecuting, our position is that you do what's necessary to keep their attention and to cause the trial to come favorably in your way. For instance, you put a witness on the stand and you're cross-examining, and the prosecution's or whoever your opponent is continually interrupting you because of the formation of the questions. You can literally have him do it in a dialogue form. So he just conversational style, if you will. So you let him say what's on his mind. Now, it can be a mistake if you have an experienced witness, but sometimes the policeman will just upchuck everything. In other words, I was going down the highway and we saw this car that looked suspicious. All of that would be objectionable if you know how to object. I have a gentleman I work with who's one of these family farm advocates that literally stopped the courtroom. In other words, there's 5 hours of testimony in which 3 questions are answered because he knew how to formulate objections. So yeah, that's pretty astounding to me. And basically all they got was his name, or the name of the witness, and where he lived. Everything else was without foundation. So if you're doing it right and you know how to formulate this, it works very well. The mistrial comes about when you happen to be prosecuting and you do something that's, what we say, inappropriate and prejudices jury, and they'll just call a mistrial on you. So, you know, it works against you either way. I would suggest that if you get a chance to get into a trial, to view one, just go in and sit and watch. And most of the attorneys are very boring, and so you're not going to see anything that goes on. But if you listen to what isn't said, then it gets to be interesting. We have would you say, a case currently going on in Minnesota in which an individual is charged with not giving a breath test, which is a crime in most states now. And I think in this state, not giving your name is one of the bigger ones that we're hitting on. Yeah, we have a couple of them in here that have been charged with not identifying themselves. In any event, if you know how to use the constitutional provisions on it, in other words, the right to remain silent, this has been very effective. All of the trials that we're involved with currently in Minnesota right now are criminal, so there are no civil ones going. So most of what I do is defensive as opposed to prosecuting. Let's change this thing back. I wanted to get into the formula for this thing so you have an idea of what they're going to do in it. I'm trying to get people to buy this book, by the way, not with us because it's not available from us, but from West Publishing Company. But let me give you an idea of what they say on just jury selection. So if you're ever in a trial, and most of you are going to be sooner or later, the first thing you're going to have to know is, besides courtroom procedure, is how do you select a jury. In the federal system, it's usually done by the judge, and he'll voir dire the jury, which leaves you absolutely nothing to do except write questions that you want the judge to ask. Now, it's a violation of due process, in my thought, to make the judge or allow the judge to ask the only questions. Because how do you ask a man if he's pregnant? And if the pregnancy would affect his ability to sit on the jury? And then how long he's been pregnant, etc. So obviously there's some questions that a judge can't ask, or if you will, you can't get a correct response. If you have ever been involved, let's say with a police officer asking questions, it's not unlike that to voir dire. So what you're looking for is biases and prejudices and what we say characteristics. Somebody with a facial tic may be totally annoying to you. It may be that you can use that also against him, but those conditions, if you're involved in a car accident, somebody with a facial tic is what you want to keep because he's aware of what an injury with a long-term effect has on you. There'll be police officers or their wives, or county officials or their wives that'll be on the jury. They may or may not be good for you. You have to know all those things. This thing allows you to do that, this book does, by making a formula, or I should say a form, in the back of the chapter for each aspect of it. I don't have this thing marked because it's a new book to me, but basically it's a jury selection chart. And voir dire is, I mean, you're going to get what you take, but the voir dire is the one chance you have to determine who's going to judge this case, whether you're defendant or the prosecutor. So you can ask them such things as opinions, attitudes, attitude about the law, other problems. In other words, some people don't like being confined at night. If they don't like being confined and you have something like the O.J. Simpson trial, they're going to be confined and they aren't going to like it. They may use that against you. How you smell that out is more fun if you know what this is all about. So most lawyers fail miserably in juries. We usually ask for the jury wheel, which is how the various counties pick juries in our area. They're picked because they have driver's licenses and they're registered as voters. That's the criteria in our area. So if you didn't have a driver's license and you were charged with no driver's license, you could not get an impartial jury. Because one of the conditions is that you have a driver's license. So it's those sorts of things that you're looking for. You would be asking whether or not the members of the jury like your client. Now, if you're prosecuting your own defense, then it's sort of hard to say, well, do you like me or dislike me? So those sort of things are a handicap, which is the reason that the next subject when we do counsel will come up, because you can now use counsel and compel that assistance as opposed to these people being able to deny it and what would you say relegate it to the realm of the professionals. You on these sheets rate jurors, so you can rate them. I used to just do it on a thumbnail, just 1 to 10, and do it blind because you have no real chance to choose a jury, and then never accept the jury. So the government or the court will often strike all the jurors for you and leave you with their choice. Now, it's never happened that we've lost a case where that's occurred on, so we've never had a chance to appeal it. But if the judge selected the jury for you and the prosecutor selected the jury for him, where does that leave you? So these are how you set up appealable issues, by the way. On the other hand, when I'm faced with a jury situation, I would insist that half of the jurors know me and the other half know my opponent. Now, it works well as opposed to disqualifying anybody in the jury that knows any of the parties. Because if the jury is to be impartial, it cannot have impartiality if it's ignorant. So charging somebody without having a driver's license is going to get him convicted automatically if anybody on the jury or nobody on the jury is aware of the issues. So you can't be compelled to have a marriage license unless you're planning on getting a divorce. That's the only incidence that I can think of that you have to have a marriage license. On the other hand, the only reason you have to have a driver's license is if you're engaged in a regulatable activity for which the license is required. So it's not hard to understand. What's hard to understand is how do you get a jury to see this? So we usually put in documentation indicating that we want to pay the jury an equal amount that the prosecution is paying them, which is in most countries called embracery. On the other hand, is discrimination also. In most areas where I'm at, the first thing they're going to hang you with is a licensed lawyer to represent you or make appearances for you, which is very detrimental to the free exercise clause. So the free exercise of assistance in the exercise of counsel is differentiated by non-appearance or non-representation. If they're going to pay somebody to represent you and the payment comes from quote-unquote the government, it doesn't matter which branch it's connected with, because in our area the public defender's office is separate for or I should say for funding purposes from the prosecution or anybody else. But nonetheless, it's still government monies. And if the money's from the same source, that means it's the same master. And if it's the same master, no matter how they try to segregate it, you're being hung. So the jury's being paid by these people, the prosecutor's being paid by these people, the judge is being paid by these people, and now your defense is being paid for by these people. I submit that's not grounds for a fair trial. So now you're back to trying to require that you be afforded the opportunity to pay them an equal amount to provide for the jury, and or bribe them in any other way, which is really what they're doing. It's highly unlikely that somebody who is never going to realize a profit from you and is always going to realize a profit from them is going to fine for you. It just wouldn't make sense. I mean, any businessman could relate to that. But putting them on your jury that know you would require that half of them know the prosecution. If that happens to be the state of Texas, you've got a real problem. Okay? Although most of them say they don't know the prosecutor or any of his minions, they all admit that they're citizens of the state of Texas, which puts them in an adversarial position to you, unless, of course, they're impartial. Can't be two things. They can't be impartial and say that they don't know you and they don't know the prosecutor, and yet they're all members of the state which is prosecuting you. I'd say that's a loaded dice. But in any event, jury selection chart allows you to write all these things down, and these are tear-out sheets, so you can just tear them out and reproduce them, and then you're on to your next trial. Also, if you'll take the time to fill this thing out, it's basically 300 pages. If you would fill it out, you would be better informed about the trial, what has to be proved, who has to prove it, what's the method of proving it, what's the testimony expected to be, what are the rebuttal expected to be, than anybody else in the courtroom. In fact, it works so well that I'm surprised lawyers don't use it more. I mean, it's after all made for them. We have a couple other little tools that I use, and I tell everybody that's in the movement to get one of these, which is just a miniature tape recorder, and it'll drive the people in the courtroom nuts, because in our state they have a monopoly on who makes a record. Now, I've had several occasions where this got in the way and provided so much distraction that the jury actually found for us because they were so vehemently opposed to the abuse that this thing brought out. For instance, we had a judge who asked me to turn one of these off. So he asked me plain, would you turn it off? And I told him plain, no, I wouldn't. Which now incurred the wrath, and he gets the bailiff ordered over there, and the jury's sitting there watching this. And so I protest, you asked me if I'd turn it off. I gave you an honest answer. Why is it that you're trying to get me, punished? So in any event, the jury was hearing all of this. The bailiff took it and in his haste dropped it. And little parts fell all over the place, which now brought a little bit of empathy up, although it was kind of a rigged deal. It was junk anyhow. But he couldn't help putting it apart. And the next thing that I usually bring with, which is very distracting to them, is this. This is a miniature tape, or excuse me, a copier. So this thing, you take the cover off of it, and and you put this on any document you want and pull it, and it'll make a copy instantly. So this is the scourge of the lawyers. In other words, they don't like this. This thing showing up means that you can get a copy within a heartbeat and put it back together and be gone. So they know what it is, and they're loath to let you near. So if you got this in the courtroom, they want to know what it is. Now, I had one judge almost dismantle it because he thought it contained explosives. Well, I admitted it did. It said a battery in it could possibly explode. Can I help you, sir?
Where can you get one of them?
This is out of Radio Shack. I don't know if they make them anymore. But this one says Radio Shack portable copier. But it works so well, and it's caused so much consternation that I carry it with just for giggles. The other thing you need if you're doing any legal work, as I pointed out, was a copy of 28 U.S.C. and then a pen and a notebook. Have you ever noticed that people that walk into a courtroom with a pen and pencil make judges, lawyers, and even witnesses nervous, especially if they happen to be quietly sitting in a corner intently observing? Now, invariably, this disturbs enough people in there that they'll send their bailiff over to ask what you're doing. And of course, usually your response should be, well, what's your name? You know, because what I'm doing is observing what you're doing. Right? And if I had your name, I'd better be able to make a record of that. I have been asked to leave a courtroom. In fact, this is a federal district court in which I had a pencil and a paper, and they took them away from me for making notes in the courtroom. The judges, and this was this guy, the judge, Devitt, who wrote the federal rules of jury instructions. So the federal jury instructions are a product of Judge Devitt. And this guy was so paranoid of us that he literally confiscated all pens and papers, wouldn't allow anything in the courtroom, allegedly because it interfered with the smooth process of the court. You know, I'd say that's the mark of corruption. But nonetheless, they banned me from his courtroom too. Depending on your position, and if you're being accused or if you're prosecuting, and you have to be very careful that you don't mix these two. When you're using their system, you're subject to their rules 100%. Now, that doesn't mean that you can't make mistakes. I think Michael showed you that if you're pro se or in pro per or whatever you want to call it, that you're not subject to the same degree of the rules as they are. And there's some court cases to hold that up. Although I don't necessarily argue against that, I usually make my own path. So it doesn't mean that what you're doing is wrong if you're doing standard 42 U.S.C. But I prefer to win under any condition. So I usually set up the issue whereby they're going to deny me some right to which I'm going to object, so that whatever happens, even if I have to do a poor case, I can always appeal it. So one of the issues that I'm most tolerant with is counsel. And because counsel comes under the 6th Amendment to the U.S. Constitution, and in most states, I think you have a dandy state constitution here, and it provides you can appear in person or by yourself. How is that stated? Oh, but before I do that, have you ever read Article 2 of your state constitution, which provides for the separation of powers? And just as an aside, it says, the powers of government of the state of Texas shall be divided into 3 distinct departments, each of which shall be confided to a separate body of magistrate, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons being of one of these departments shall exercise any power properly attached to either of the others, except in the instances expressly stated herein. Expressly stated herein means in the Constitution, not in the statutes. Now, if that's true, then as far as I know, no police officer carries judicial functions, which means that he cannot issue process, particularly summonses.
Or citation.
Well, citation is a convoluted term used to identify a complaint summons combination, which has been authorized by the legislature, which is forbidden in Section 29, which says that to guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate, and all laws contrary thereto or to the following provisions shall be void. So any provision following it also. And that includes separation of powers. So they could not lawfully make a law that would allow a police officer to issue process. Did I answer your question? It's really, in my state, we've skinned them on this several times. Yes, sir?
I was wondering, I understand that in federal court you can't take a tape recorder in. How do you get around that?
Well, in federal court you're not supposed to. You can ask permission to. I carry it because it's just like I carry my pencil. You know, it's just part of me. And but you can't even bring it in a federal courthouse, in theory. I just choose to do it. Now, normally what I carry is an operative one, because I want them to challenge me on it. So far they haven't. See, I'm always willing to be the guy that's almost wrong. But if it's inoperative and I'm carrying it for repair purposes, they can't hardly say that I'm trying to use it, right? So you can remove a battery or just take a wire off. You can do anything you want. But you know, I'm aware that the sign is coming to the federal building. And of course they also say that if you come in here you subject yourself to search, which is the reason I don't usually go in. In fact, I'm banned officially from several of them. Well, because the right to be secure in a person's house's papers and effects shall not be infringed. this federal building in most cases is a rental facility. So it's not, if you will, U.S. government, even though it's controlled by, but it has to be sold, and now under U.S. government power before that would be lawfully effective. So, you know, they just don't want me in there. I've had the privilege of being escorted rather violently out of federal buildings. I was cornered in an elevator by 3 of these crazy agents, and one of them was female, and they had this small elevator. 2 of them drew their guns, and the woman stood behind me with a threat to put a chokehold on me if I so much as breathed. So they escorted me out the door. This is a glass-fronted building, so I went peacefully and found a friend of mine sitting outside the door. And he asked me what happened, and I said, well, I'm afraid to tell you because it might be top secret. And so I said, but you can ask those guys, you know, they'll tell you. And so they said that if I came back in the building to him, that they were going to arrest me for trespass. Now, how is it that a federal official, guard, if you will, can make law? See, before you can be arrested for trespass, you must be lawfully unable or lawfully notified that you can't be there. He's incapable of giving lawful notice. So I went back in. And they brought their so-called senior guy out there, and they were going to do this arrest thing. And I said, well, there's 2 conditions under which you can arrest me. One is if I did something unlawful, and the other one is if I'm a threat to the security of the building, which would be unlawful. And which one of those is it? He said, well, you're guilty of trespassing. I said, well, I could confess to that if I was willing to lie, but I'm not willing to lie. Say, if I were trespassing, then I would have somebody of competent stature able to tell me and to show me that I wasn't supposed to be here. In other words, you had to be communicated this. So he goes and gets his 3 flunky agents again, and he asked him in the presence of, we got newspapers around, in the presence of all these people, whether or not I was banned from the building. And he said, yes, we banned him. So then he said, what was your authority for banning him? Well, because we told him we didn't want him in here. He wouldn't submit to a search to go in a courtroom. And the newspaper's listening. And so one of them say, well, is that the new law that everybody has to submit to a search before they can go in a courtroom? And of course now they're not asking anymore, not answering anymore, and they disappear behind their little doors. I had the privilege of being drugged behind their doors and interviewed for potential terrorist inclinations, because they thought if I wouldn't go through the search thing, I must be doing something evil. And all I said was that if I go through this, that I would be subjecting myself to an unlawful search. And he said, well, why would it be unlawful? Everybody else does it. You know, the logic was overpowering. So when I declined to, they hustle you behind these doors, and they put you in these cuffs, which is an unlawful arrest, and then he put you in this little detention thing with a glass thing on it so they can talk to you. So you just got room to stand behind this door, and they talk to you. And of course, I'm fairly deaf. At my age, I can afford that. And so they said a lot of things to which I wasn't responding. And then they would open the door and says, well, can't you hear us? I say, oh, excuse me? And then they'd try out the mic again. And of course, it worked fine. I said, it must be the switch when you close the door. You're going to have to put somebody in here to translate. So they eventually gave up and threw me out of there, too. But if you get into the way the Constitution is written, and all of the aforesaid was to be strictly construed, then they could not lawfully question me. Not in Texas, not in Minnesota, not in any state, without violating the right of the people to be secure in their persons, houses, papers, and effect. So my question, and in fact, this is what I suggest people do, is memorize your Article 1, because then you can ask every question with that as the foundation. You know, does not Article 1, Section 29 provide that everything written previous to Article 20 or Section 29 is exempted out of the powers of government? Yes, it is. Well, then how is it that my right to trial by jury is infringed by you? You say that a petty misdemeanor can't have a right to trial by jury. I read that it says the right of trial by jury shall remain inviolate. I thought inviolate meant without ability to color it. And then it says the legislature shall pass such laws as may be needed to regulate the same and maintain its purity and efficiency, provided that the legislature may provide for the temporary confinement. Say, now here's an amendment that doesn't match the first one. You can't have a temporary confinement without trial by jury. I don't care if it's even in the Constitution, because that's not what the original Constitution said. And the original Constitution is inviolate. Okay? Otherwise, your forefathers' words meant nothing. But anyhow, I mean, that's my method of doing it. In fact, all of my pleadings are devoid, in particular when I'm defending, are devoid of any case law. And I only use the constitutional provisions. So if you're being charged with speeding, then you're asking for the injured party. In effect, you're saying that you have a right to summons witnesses in your defense and that you summons the state of Texas. They're the ones that could identify the extent of the injury. But the police officer is basically a hearsay witness unless he's the injured party. He can testify about it, but he can't testify to it. So nonetheless, we have a gentleman in Kansas who's a dear friend of mine who has successfully prosecuted everybody who ever stopped him. Right? So if you start doing it, then pretty soon it's not worth stopping you. In any event, if all courts shall be open and every person for an injury done to him in land, goods, person, or reputation shall have a remedy by due course of law, means that in this state judges are suable, because that's what it says. Every person. So obviously there's no capacity to overwrite this. So I would say that these people would have a real long stretch. Now I'm not saying you'd be successful, but I'll bet you'd hit the Supreme Court. And this is the basis for your suit. In other words, this individual injured me, not in his capacity as judge, but using that as a shield. So John Smith did injure me, and I want the remedy given here. Now, because there's nothing here for a remedy, you invent one. Okay? Now, you're not restricted, by the way. Being resourceful is what changed all this law in the first place, because all of the amendments come about because somebody found a way around it. And so they amend it or they write a new statute. So you've got the same thing here on the bills of attainder. No bill of attainder, ex post facto law, retroactive law, or any law impairing the obligation of contract shall be made. So now your business doings, given that law, should change. You should not be operating as organizations or associations for profit. You should be doing what the law says, not affording the state an opportunity to impair the obligation of contracts. So everything you do needs to be done by contract and not by association or groups. So if it's done by contract, all of a sudden the state has no method of inquiry into your business. Okay? The law says it can't be done. Now, that's all your defense. All you're saying is that the activity of the state impairs the obligation of the contract. As an instance, let's say that I have you grow food for me on your farm, and I want the food delivered to me as the condition of the contract. Now, your delivering food to me does not affect the use of the public highway. Whereas everybody else usually carries their food in their belly, at least until they get to the bathroom. You're just carrying my food in the back of the truck before it gets to my belly. So it's incidental, if you will. The use of the highway is incidental. It is not a direct use. Now, if you're stopped, then you can use this as a defense, that you're impairing the obligation of contracts. I'm lawfully able to make a living in this state. I asked the state for no privilege. I made an agreement to provide food or sustenance for an individual in exchange, and I've done so. Now, for you to cause me to get a license to affect that contract impairs the obligation, right? Or any variation thereof. You almost have to be as resourceful as they are devious. Every time they write a law, you figure out a way around it. Yes, sir?
I was just going to ask about this, what you're saying right now. I filed a DBA. Now, I did not incorporate myself. I just went down and filed a DBA when I started my business, and I work for myself. Actually, I work for other people. So all my stuff is done by contract.
Sure.
But does the DBA hinder me in my obligations of contract?
Well, to the extent that the state can regulate what you're doing. So if you're doing business as First Bank, I'd say it's what you're doing that brings you under the state.
Okay. I do computer animations. I mean, it's not a regulated industry.
Okay, so there's no reason to have the DBA.
The reason I have the DBA is to cash checks.
Yeah.
Now, I put the DBA in my name. I am Kevin Dorita doing business as Kevin Dorita.
Well, the easiest way is if you, instead of taking checks, require cash. If they don't want to give cash, for instance, this seminar would cost $300 if you pay by check. It's $150 if you pay by cash.
Well, yeah, but I do $20,000, $30,000, $40,000 projects.
Yeah, that's all right.
They're not going to. Nobody pays me in cash.
Well, I understand what you're saying, but so you need a way to process it. As long as it doesn't involve you in the state, I shouldn't see any difficulty with it. But you could do the same thing by, what would you say, suggesting that you are operating as a contract, as opposed to operating by contract. Now, it's a little vague, but consider if I and my business partner, and we live in Taiwan, decided we wanted to do computer stuff here, but we don't want to come here because we don't like this, you know, what would you say, socialist nightmare. So in any event, What do we got left for time? Okay. So we don't want to get involved in a socialist nightmare. You come over there and we say we want to invest. And so what we want you to do is operate our investment in the States. Could you do that? Now, you would be operating, if you will, in the contract. So you could do nothing that we didn't want done, right? And
Right.
yet you wouldn't be a DBA, would you?
Not
So
necessarily.
you'd be representing the contract. And that's
Okay.
all it would be. So you don't have to file that. But it's just another way to look at things. It's one of the best ways. It beats a trust.
I'm led to believe that DBA is doing business as.
That's correct. DBA is doing business as. Of course, you could call it a lot of other things too.
Dwayne?
Yeah.
Yeah, in your scenario, quickly, with a driver's license, would that scenario still hold?
Well, the driver's license, if you're applying for one, you should apply for one if you need it. So there's nothing wrong with you operating for profit and gain on the highway if that's what you choose, but you're limited by the license.
Well, I know, but you were carrying food to the farmer.
No, it's
and-
not a licensable or regulatable activity. See, where I come from, it's accepted fact that no license can be required to sell or peddle the produce of the farm or garden. That's what the law says.
So in the scenario, one has nothing to do with the other. In other words, you're carrying food to the farmer, and the officer says, you don't have a license. And you
Right.
say, well,
I'd say your
No, I'm
powers of observation are not diminished by your age. No. But nonetheless, no, I use a commercial license on a regular basis. And what I use it for is to establish that I'm not engaged in a regulatable activity. And the scenario goes thusly. Were I to misrepresent to the state that coming to visit you people was a licensable activity, I would be violating their obligation not to regulate the right of the people to peaceably assemble. Because if peaceable assembly requires that I get their permission to do so, it's obviously not a right. It's now a privilege. So conversely, the use of the public way for profit and gain is regulated, provided I've set up the business on the highway, or the use of the highway is the business, which a corporation would do. A fiction is immune from what we say prosecution, except to the extent of its asset value. So it's licensed. So if it injures you on the highway, it must be able to pay for the cost or the injury. You, on the other hand, are subject to the common law right, which is to make me whole for every injury to my person, property, or character. There's no correlation between the two. If I have to have a license to go down to get a license, I'm never going to get there. It doesn't make sense. It's absurdity. So what you're doing then is admitting that you need a license. So you're hiring public transportation, which is licensed, to take you down to obtain a license. You know, it's asininity. Yet 90% of the population believes you have to have a license. I submit that if I had a marriage license, I'm married to all the women in here. Now, it's very singularly relegated to that particular application. So when I apply for a license, it's to do that which, by law, would be illegal, unlawful, a tort, or a trespass. Okay? And coming to see you guys isn't illegal, a tort, or a trespass. Nor could it constitute it if I did it at 90 miles an hour. It just, I got here faster. Some of these traffic issues, we don't have time to go from now. We got about 2 minutes left. When we get after the break, we'll hit some of them. Some of the traffic issues are so entertaining, and yet they're very informative when you try to put this together. If you were to admit to a police officer that, or if I were to admit to a police officer that I required a license to get down here, it could be construed to be a violation of federal law, which is giving false information regarding interstate commerce. I'm not in interstate commerce. Yet crossing straight lines or state lines would involve interstate commerce according to their reasoning. So the gentleman from Hawaii, Zane, who's been charged with what we say falsifying Hawaiian material or falsifying government documents, Texas has no capacity to enforce Minnesota law or Hawaiian law. So for them to charge it is false. In fact, it's criminal. And then for them to say that he falsified their paperwork is just patently wrong. There's nothing in Hawaiian law that I'm aware of that says you can't change anything on the form to correct it. You know, if the form is misprinted and it says asshole size, and you put it, oh, I see, hat size is what it meant. So you just, you don't have to put this down. But that's what they're telling you, that it would be a criminal act to do so. But nonetheless, a lot of this is just plain good entertainment when you get up and do it. We have applications in Minnesota that are separate, so a commercial application is different. And some of the questions are unanswerable. You know, they have one question on the test that says that you're going down the highway, this presumes you're driving a truck, and you're expected to stop in a reasonable distance. Is that distance the length of a football field, twice the length of a football field, or the length of a soccer field? And I said, I don't play football. How in the hell would I know? No, I don't play soccer either. So these questions are just out of the blue, and these guys sit down and dream up this crap, and you're supposed to respond to. Now, they did change that question because I made so much of a stink out of it. But they think that everybody's involved in their activities. In any event, what do we got left on that, Peter? 2? Oh, 3. So, well, we have time for a quick story. I had a gentleman that followed me from the southern part of the state in a truck, and as we were coming up across the line, and I have a truck, and I go by this weigh station, and which is a no-no. You can't go by a weigh station if you're driving a truck. Now, this truck happened to be my transportation. It was just a good bargain, and I couldn't resist it, and I like big wheels. So I'm banging up down the highway with this thing, and the guy behind me gets on the radio and says, hey, you missed the weigh scale. I said, no, I didn't miss it. I'm not engaged in that activity. I'm not going to stop. So, and this is right near the Minnesota border. So pretty soon here's this Iowa patrolman. He comes up there, and I park literally right on the line. So the truck's half in and half out. And he comes up to my truck and said, I need to see some identification. And I do my standard dog and pony show, and ask him if it would be advisable for me to remain silent, or was he going to arrest me? And he says, well, I'm going to arrest you if you don't give me some identification. So just hold out your hands. What's he arresting you for? There's no law, and in particular in Minnesota, they actually enforce this, the right to remain silent. So, of course, he's in Iowa yet, and I'm in Minnesota. But he's standing there, and he's got this thrilled look on his face, because he's going to have a truck to confiscate, and he's going to have somebody to incarcerate, and I'm just living it up. Because I got a driver's license in my pocket. I just can't show you unless you let me mislead you. So I'll tell you any lie you want to hear. Okay? And he says, you better not lie to me. I said, well, good evening, officer. That's a lie. That's neither good, and neither is it evening. Of course, it was afternoon, but it's neither good nor was it evening. And I doubt you're an officer. Right? Officers are, if you will, by appointment. You're a paid employee. You punch a time clock. And he said, well, that may be true, but I'm still a police officer. I said, well, police is the word for policy. Its root is policy. So you're a policy officer at best. He said, I ain't putting up with this blankety-blank stuff. And so now my friend's coming up behind, and he parks behind the policeman, and he gets nervous. The policeman does. Because, two big trucks, one has to back up, the other has to go forward. But nonetheless, and I'm making hand signs, just for giggles. And this policeman is extremely nervous, so he goes back to his car, and you hear him calling for backup. And I said, well, tell him to park at least 15 feet behind his truck, because we have another truck coming, and we want to be able to, which is not true. But they don't care. Anyhow, pretty soon you've got the third police car lined up there, and I'm still making my hand signs, doing this thing. And they finally get the idea that you're just jerking them around. Now, the question was, why didn't you stop at the scale? Okay. And of course, I said the scale wasn't open. And he said, everybody saw it was open. I said, now you know why they don't let me drive a truck. But he finally talked me into giving my driver's license so that he could look at it, and confirmed his worst suspicions that this guy was trying to engage him in something unlawful. And I even told him I have a piece of plastic for morons, idiots, half-wits, and assholes. But otherwise I wouldn't show it to anybody normal. When the lieutenant came up for his support, he decided that it was worth seeing, even if he had to take that kind of abuse. So now when you get to it, what are you looking at? I'm not engaged in a regulatable activity. This truck has nothing on it. It's got my sleeping bag at the back end, but that's all it has, and it's my private conveyance. It's not registered for highway use. Now, any farmer in Minnesota would tell you that you don't have to register trucks in Minnesota, and yet almost all of them do, right? Because they don't want to be stopped. We proved it. I parked my trucks unregistered on the highway because I own a farm, and dared them to give me a ticket. They just don't do it. Now, when you're least expecting it, they do it. Right? They tow you. So you have to, count the cost. Are we out of here now?
Keep going.
Okay. But in any event, when we get into the courtroom scene again, in fact, we were going to set up a jury trial just so you guys get a chance to see how it's played. You only got one on that? Is that what you're saying?
1 minute? 1 minute? Okay, yeah, then we're going to take a break.
We're going to take a break.
We are, he stumbled uncontrollably for the equipment. We are going to take a break. Mr. Rogers is available on a fee basis for you consulting on your legal problem. We will also remind you that we have 12 and a half hours of the false witness defense on audio and video. And lastly, we'll remind you that the Erwin Rommel School of Law brings Michael Brown to your shortwave radio every Sunday evening, Central Time, at 10 p.m. And we are on WWCR at 7.435 megahertz. And that's Michael Brown's Solutions. And we urge you, it's 1 hour, we urge you to tune in Sunday evenings, 10 o'clock Central, at 7.435 on your shortwave. And you'll be amazed and amused at what you can learn for free over the shortwave. We're going to take a short break, and we hope you do too. We'll be right back.